Be with us tonight to monitor our show. So let me call to order the January 25th, 7 o'clock hearing of the Board of Appeals on the Thayer Nursery matter. It's 7 o'clock, and my name is John Leonard. I'm chairman of the Board of Appeals. With me tonight are two fellow Board of Appeals members, Jeff Milton and Theodore Dabo. Our first hearing on this matter was, I think it was January 4th, and we had an evidentiary hearing, and at that time, earlier in the afternoon, Mr. Dunn and given the board access to a Dropbox, so-called, of materials that he wanted to offer as evidence at the hearing, and regretfully, the board didn't have the full opportunity to review those materials. So at the conclusion of the evidence, we continued the hearing to this evening to allow the board members and other members of the public to review the materials that Mr. Dunn submitted. Since that time, we did receive another communication from Mr. Dunn, a little bit on the late side at 5:20 this evening. But Mr. Dunn writes to the board that he thinks the board would benefit to have as evidence at the hearing and to review section 3, subsection N, as in Nathan, of the bylaws, a 2016 special permit to Mr. Oldfield and Maggie Oldfield in Thayer Nursery Corporation, a 2019 amendment to the 2016 special permit, and the 2019 renewal of the special permit. So we thank Mr. Dunn for submitting those materials as additional evidence of the hearing. Let me just briefly summarize for those people who haven't been watching us at the previous hearing. This matter involves an application by Philip Johanning and John Rowe of Milton, Massachusetts, by their attorney, Matthew Dunn. It's dated October 31, 2002. It's on file with the Board of Appeals, and it's appealing the denial of a request for enforcement. The request sought by Mr. Johanning and Mr. Rowe through Mr. Dunn sought an order compelling Thayer Nursery Corporation to cease operations as a commercial landscaping business at their properties on Hillside Street and Forest Street in Milton, Massachusetts. At that first hearing, we heard from Mr. Dunn, and we also filed a Mr. Prondek's response to the application for enforcement, and we have that as part of the evidence. I'm not going to go into that. That's all of these documents are on the website if anyone wants to review them. Mrs. McGetrick is representing Maggie Oldfield and Josh at the previous hearing and at this hearing as well. Mrs. McGetrick did file a memorandum in the form of a letter dated January 4th, 2023, on file with the board, going through in detail her reasoning that this enforcement action should be denied by the board, and that's all of record too. And reading all of this stuff, I think, will cause more confusion than being of help. So I think that's a fair basis as to where we are. Let me just ask you, Mr. Dunn, with respect to the additional documents that you filed with the board, do you want to be heard on
Yeah, and
consistent with how they help you?
Thank you, Mr. Leonard. And I don't mean to inundate the board with, volumes of information at the last minute. The only reason why I submitted it is there's a couple of relevant provisions in really in the bylaw amendment in the 2016 special permit that I just wanted to bring to the board's attention. The 2019 permit is really a renewal of the 2016 special permit. That's why I'm presenting the 2016 special permit to the board. There is an amendment to the 2016 special permit that was made in February 2019. So that has really no relevance to anything before the board at the moment. I just, for purposes of completeness, I wanted to just provide that. With regards to, and I don't want to cause any delay here, but I never got a copy of Thayer's memorandum in this matter. So Ms. McGetrick, if you could forward that to me at your convenience, or I can, if it's on the board's website, I'll obtain that. But I'm ready to proceed regardless of that. So I just want to start because this really, the information that I provided previously, it's my position that information shows almost definitively that it's the Thayer Nursery Corporation that is running the landscaping business at the Thayer Nursery site, and that Maggie Oldfield and Josh Oldfield are officers, directors, and employees of that business. So, and as the board's aware, the land court, pursuant to an appeals court decision, annulled the 2000 special permit in favor of the Thayer Nursery Corporation. So the issue before the board is, how can the Thayer Nursery Corporation operate at the Thayer Nursery site without a special permit? Because the business is being operated in a residential district. It's a residential A and a residential AA district. And one of the, I guess, with the core issue that's before the board is whether or not the Maggie and Josh's interest in the special permit, which the land court and the appeals court indicated that they were qualified applicants to obtain, whether that interest can be assigned or transferred to allow the Thayer Nursery Corporation to operate the business on the subject site. And so it's our position that those rights cannot be assigned. And I think that that's spelled out in the 2016 special permit that's been incorporated into the 2019 special permit that's currently active. And I just kind of like to walk the board through my logic here, and obviously the board is so the board can be prepared and educated to make its decision in this matter. But the bylaw amendment that we're talking about is section 3, subsection N of the bylaws for the town of Milton. I'd just like to direct the board to subsection C, which is operators of a landscaping business. That's one of the requirements under the bylaw for being able to acquire the special permit and operate on the premises. So it's got a couple of provisions. It says the operators of a landscaping business shall be operated by the applicants for the special permit. And so because of the annulment of Thayer Nursery Corporation's rights in the subject special permit now, the applicants at this point would be Josh Oldfield and Maggie Oldfield. So there's no real dispute here that that they're applicants under the special permit. So and then the next provision of section C is the operators shall be named in the special permit, and Josh Oldfield and Maggie Oldfield are named in the special permit, so we don't necessarily have a problem with that. But the next provision states operators shall have an ownership interest or leasehold interest in the business premises. Now, Josh Oldfield and Maggie Oldfield do not have an ownership interest or a leasehold interest in the business premises. In their 2016 special permit application, and I'll refer you to paragraph, I believe it is C, it says operators of a landscaping business. States subsection N period 7C requires that there shall be operators of the landscaping business. The operators shall be Joshua Oldfield and Maggie Oldfield. So they're identified in the special permit. However, Josh and Maggie do not qualify as operators under subsection N7C of the bylaw amendment because they do not have an ownership interest or leasehold interest in the business premises. The business premises as identified in the 2019 special permit is 270 Hillside Street in 0 and 24 Forest Street. Now, according to the 2016 decision, and I'll refer you to paragraph B, and then there's a couple of subsections under that. It says the business premises identified is 270 Hillside Street is owned by the Oldfield Family Limited Liability Company and leased to the Thayer Nursery Corporation. In 0 to 24 Forest Street is owned by the Oldfield Family LLC and leased to the Thayer Nursery Corporation. So neither Josh nor Maggie hold an interest, either ownership or leasehold, in any of the properties that comprise the subject site that Thayer Nursery, the business, operates on. So they don't qualify as operators under the special permit. And that's important because going back to the bylaw amendment, subsection N9, that's at 116 of the documents that I provided to you. It says that the special permit shall remain in effect during its term for as long as the land and landscaping business use is operated by the permittee in accordance with the special permit. As I stated before, here the remaining permittees are Josh and Maggie Oldfield. And as I stated before, they're not the ones that are operating the business. It's the Thayer Nursery Corporation, based on the evidence that, as I interpret it, that I provided to the board, shows that this entity is the one that's operating the Thayer Nursery business on the subject property. And Josh and Maggie Oldfield do not. And they also don't own the land for the reasons that I stated before and as identified in their 2016 special permit that was adopted into the 2019 special permit. So under the bylaw amendment, that would require Thayer Nursery Corporation, the Thayer Nursery Corporation, to apply for a new special permit. And that's set forth in the bylaw amendment and the last paragraph. And it's also set forth in paragraph number 9 of the 2016 special permit that was adopted in 2019. So just in summary, and I'll close with this, as I stated before, the evidence presented indicates that the Thayer Nursery Corporation is running the Thayer Nursery business on the subject site, and that Maggie and Josh are employees, officers, and directors of the Thayer Nursery Corporation. And they are not, Thayer Nursery Corporation has no independent rights to qualify for the special permit to operate that business on the site, because those rights were annulled by the final decision of the land court that's not been appealed. So I guess the issue before the board, again, is whether or not it is permissible for Maggie and Josh Oldfield to transfer or assign their personal rights in the special permit to the Thayer Nursery Corporation, an otherwise unqualified applicant, to run the Thayer Nursery business on the subject property. And I know that that's confusing. I'm happy to answer any questions that the board has, but otherwise I would rest with that presentation. Thank you.
Great. Thanks, Mr. Dunn. Let me do two things. Let me ask Mrs. McKettrick, do you want to be heard on Mr. Dunn's contentions at the present time?
Not at the present time.
Okay, all right.
Your discussion.
Great. Let me ask my fellow board members whether Mr. Mullins, you have any questions of Mr. Dunn regarding his summary of his position in this matter, or regarding any of the evidentiary documents that were in the Dropbox.
What's the evidence of an assignment or a transfer of the special permit to the corporation?
I would just say that the operation of the business itself, it wouldn't be, there wouldn't be a permissible, I mean, I don't have any written documentation showing the assignment. But if there isn't an assignment and Thayer Nursery Corporation is operating on the subject property, I don't, based on the land court decision, I don't see how that would be permissible without, in the bylaws. I don't see how that would be permissible in the Residence A district.
Doesn't the land court decision say that Josh and Maggie were not prohibited from using Thayer Nursery to facilitate and assist them in operating the nursery?
Right, but I don't think that their nursery is assisting anybody. I think their nursery, that's put sort of the cart before the horse. It's their nursery corporation that's operating the business on that premises. It's not, they're not assisting Josh and Maggie. Maggie and Josh are employees and officers of their nursery.
But Thayer Nursery is only named in the land court decision because that's the entity, that's the defendant in the action, right? So it just feels to me like there's a big leap here, that there's actually been an assignment or a transfer. I don't see any evidence that the permit holders are abdicating any of their responsibilities under the permit or otherwise transferring them. Are there?
I don't see any evidence. I actually see contrary evidence that Josh and Maggie are not personally running a landscaping business on that property. The evidence that I presented to the board shows that their nursery corporation is operating a landscaping business on that premises.
But I thought you positioned your introductory remarks by stating to the board that the issue in front of us was whether or not they lawfully transferred the permit.
Because that would be the only way that their nursery corporation could lawfully operate on that premises.
Don't see any evidence of that, though. Can't be imputed, right? I mean, it has to be transferred by something, right?
Well, if their nursery, if the board were to find that it's their nursery corporation that is operating the business on that premises, then the next question that has to arise is, because the property is located in a Residence A and a Residence AA district that prohibits commercial uses, what gives their nursery corporation the right to operate in that location?
Is that matter?
It qualifies for a special permit under subsection N.
Is that matter in front of us?
It does not.
Is that question in front of us?
What's that? I'm sorry, I'm not following.
The next question, is the next question in front of us?
That's the purpose of the enforcement action, yes. We're saying that the enforcement request is that their nursery corporation has no rights under the special permit. And if it doesn't have rights in the special permit, what gives it the right to operate the business in the Residence A and Residence AA district? That was the zoning enforcement request. And we're saying that it does not.
Correct. I know, I understand that, but you're also alleging that there's been a transfer here, and I don't know why there can't be a different entity that's the operator. I don't see any evidence of that. By the way, it feels like we're making all kinds of assumptions here that need not be made. Isn't the issue really whether the permit's been validly issued, and in the absence of it being transferred, why couldn't the permit holders retain any number of organizations to assist it in operating it? No?
My argument, respectfully, Mr. Mullen, is that the permit holders are not assisting anyone. Their nursery corporation is running the business with the assistance of its employees, which are Maggie and Josh. So
Okay.
we see, I guess, I see it absolutely.
No, I'm not making any- look,
180 is
I'm catching up. Look, I'm reading this stuff and I'm listening to you, and I have some questions. That's all.
Oh,
I'm not
absolutely.
reading
I'm happy
conclusions.
to answer them.
Yeah, I appreciate that. No further questions right now. Thank you.
Okay, thank you,
Thank
Mr. Mullen. Ted Aber, do you have any questions of Mr. Dunn?
Yeah, I've read the opinions multiple times, the land court and the appeals court. And I have written down here in my notes. You made the argument to at least one of them, maybe both of them, that only Thayer Nursery Corporation was operating the business on the property. And the court rejected that. And it said the evidence was that you couldn't really tell what was personal operation and what was corporate operation. And then the court went on to say that there was no evidence to say why the corporation couldn't operate there through the individual permit holders, who were Josh and Maggie, who are the sole owners, the sole directors, and the sole officers of the corporation. I mean, they own the corporation. They're operating certainly the corporation, and through the corporation operating the business. And all of that was in the two opinions. I also read at least part of the bylaw and the special permit provisions, which named them as operators, Josh and Maggie, responsible for ensuring that all requirements, terms, and conditions of the special permit are complied with. And it also requires that an operator or an authorized representative shall be on site during regular business hours. So, you know, it indicates in there that Josh and Maggie could use an authorized representative in their stead on the property if they wanted to. And it doesn't say that the authorized representative can't be a corporation or an employee of the corporation. And it also doesn't say that they can't use a corporation in operating the business. So I really, to be honest, it doesn't seem like you're paying much attention, with all due respect, to the decisions in this case that we have in front of us.
Well,
I mean, there's other provisions in the decisions too, but that's basically all that I saw the two decisions as doing with respect to Thayer was to say that they could not be a holder of the permit. Beyond that, it didn't say anything. And in fact, in its decision, it talked about how they didn't see a problem with Thayer participating in the operation of the business. And they also said that, I think they rejected the argument that Thayer could be viewed as the sole operator of the business. So I don't know whether that's a question or I'm just making a statement, but I mean, how do you deal with those things in the case? And your evidence that I went back and I looked at what you provided with us, and thank you for providing us with that information. But looking at the statement of facts in the land court decision, the most recent land court decision that was decided, and the facts that they say were presented, they're basically the same thing that you gave us. And based upon which they said that there was no problem with Thayer Nursery being, participating and operating the business, although they couldn't say which part was personal operation or individual operation and which part was corporate. So I guess my question is, how do you deal with that? I mean, it seems to me to be contrary to what you're saying, with all due respect. And I read these things a lot, over and over.
well, let me try to color some background for you. I've been involved in this case since 2013. There has never been.
Have we, John, haven't we?
Yeah, you have. Yep. So there's never been any factual finding or presentation as to who is operating the business on that property. And respectfully, the 2019 or the most recent decision from Judge Rubin was not based on facts presented as to who is actually operating on the business. That was the decision in that case was based on procedure, based on a doctrine called res judicata, that basically said we had the opportunity to present information concerning the operation of Thayer Nursery in 2016, and that the court was dissatisfied with the level of evidence that we presented at that time as to who was operating on the property. But we've never gotten a substantive analysis as to who is actually operating the business on that property. And I think that that's important because, again, in order to operate the business on that property, you need to hold a special permit. And
I don't see that in the, I don't see that in the bylaw.
So-
You know, it doesn't say that you can't, that somebody else can't be operating the business in conjunction with the individuals.
okay, but
It doesn't say that.
okay, but the individuals are not running the business on that property. And the evidence that I presented to you, volume.
Who decides, excuse me, who does, if they want to buy a new truck or something, who decides? It's
The
Maggie or Josh. If they want to, if they're doing a project, and I mean, I'm just you know, if they want to do a project, is it a corporate entity that decides, or is it, you know, an individual who is an officer and director of the corporation? I think that's what the court was trying to say when it said there's nothing preventing them from operating through a corporation.
But the evidence that I presented shows that they are not operating through a corporation. The corporation is operating the business on the property. So if we have a disagreement as to corporate authority and corporate law, then that's fine. But it's been my understanding that a corporation is a separate and distinct legal entity than an individual. So if an individual is taking action on behalf of a corporation, taking action in the name of a corporation, they're doing so as an officer or a director or an employee of that corporation. So if you were to pull I provided the board with evidence that everything that's going on there is being done in the name of Thayer Nursery Corporation. Whether you want to recognize that or not, that's entirely up to you. But the evidence shows, and I'm not making it up, that it's not Josh and Maggie. And if you know, if we want to perpetuate this legal fiction, that it's Josh and Maggie using Thayer Nursery Corporation as an assistant to run the business, that's simply not what's happening. It's not happening. So, you know, you can make any decision you want under that fiction, or you can apply the facts that are presented to the board that show that Thayer Nursery Corporation is the entity that's operating there, and they don't have a special permit to do it. And it's in a Residence A and AA district that's restricted with regards to commercial uses, and they don't have the permit to do it. So, you know, that's the best argument I can make. That's the best response I can make to you. And you guys, you know, you're very educated people. It's a very impressive board. You know, I respect whatever decision you make. I may not agree with it, but I respect it. I just happen to see it different than you, Mr. Dauber, but you know, that's our position.
Okay, so just one last question, then I'll let somebody else ask questions. But so your argument before us then is basically that, well, not basically, but is that Thayer Nursery Corporation is the sole, you know, operator is the wrong word, but Thayer Nursery Corporation is solely operating, and Josh and Maggie have no part in operating the business.
In their individual capacities. They operate on the Thayer Nursery site as officers, directors, and employees of Thayer Nursery Corporation. Thayer Nursery Corporation operates the business of Thayer Nursery on that site. What is confusing about this is that there are actually identical names mean different things here, right? There's the Thayer Nursery business that's being run by Thayer Nursery Corporation.
What about the provision about them being able to use an authorized or have an authorized representative on the property that's in the bylaw instead of themselves?
Then they can use Thayer Nursery Corporation to accept mail, but Thayer Nursery Corporation is not allowed to operate the landscaping business on the property. You need a special permit to do that, and they don't have it.
Okay, you're just saying the same thing. Okay, all right, I understand what your position is. That's, John, go ahead. Sorry.
Okay, no, that's fine, Ted. Mr. Dunn, I just have one question for you. In all of your analysis this evening, you haven't mentioned the building inspector. And I think the evidence is irrefutable that Mr. Prondak actually went to Thayer Nursery as part of his investigation of your application, interviewed Maggie Oldfield, and concluded based upon his interview that the nursery business was being the landscaping business, excuse me, the landscaping business was being operated by Maggie Oldfield and Josh Oldfield. How do you counter that? Other than with the arguments you previously made, do you have any other evidence that you haven't mentioned as to why the board shouldn't give credence to Mr. Prondak's investigation?
So Mr. Prondak has a very difficult job and he's placed in a very difficult situation. And I appreciate him investigating our enforcement request. Unfortunately, I don't think Mr. Prondak had the written information and documentation before him that I presented to this board at the time he made his decision. He spoke with Miss Oldfield, and I understand Miss Oldfield's position. I disagree with it based on the information that I've reviewed. But I understand where she's coming from, and I disagree with it. And apparently Mr. Prondak agreed with Miss Oldfield's statements and her position. Our position is contrary to that, and it's based on the information that's circulated for the last 10 years in this case. And I know that you guys have been intimately involved in this, and I appreciate it. But again, I have different information than what Mr. Prondak was able to review, I think, and that's what I provided to the board.
Okay, well, thank you very much, Mr. Dunn. Appreciate very much. So you have concluded your presentation, I believe. Is that true?
Yes, Mr. Leonard. Yep.
Great.
Chairman, can I ask one more question?
Of course you can. Mr. Mullen, please.
Matt, Mr. Dunn, is there, are you making any allegation that while there are some legal niceties here regarding Thayer Nursery Corporation or any of the other entities that the Oldfield family has created over the years to be involved in the property, is there any allegation that there is anybody other than Josh Oldfield and Maggie Oldfield involved in the operation of those entities?
Not that I know of.
Third party here is this really about, at the end of the day, not having the right corporation in place? I mean, there's no other person who's controlling this thing.
Not that I know of.
Okay, all right, no further questions. Thank you.
Okay, thank you, Mr. Mullen. Mrs. McGetrick, do you want to be heard while we have this hearing open and we can?
Yeah, just a few responses and comments. I think the appeals court and land court decisions are very clear in saying that the individuals hold the permit, the individuals being Maggie and Josh Oldfield, and that the individuals can use a corporation to run the business. And just to provide a little bit more background and history, the reason the appeals court ultimately decided the corporation could not hold the permit, the landscaping permit, was because the original nursery permit issued to Thayer was issued to the parents individually and not to the corporation. Corporation already existed at that time. Parents were already using it to run their business, but your Board of Appeals at that time was very clear that they wanted the permit to go to the family, to the individuals in the family, the parents at that time, in order to limit its duration and to associate it very directly with the family and the family's reputation and in their neighborhood and in the town. So as a result of that original nursery permit, the Court of Appeals decided that the that the planning board was incorrect and should not have issued the permit both to the individuals, Maggie and Josh, and to the corporation. The only thing that they turned down out of that original decision was the issuance to the corporation. They said it's fine that it's going to the individuals, Maggie and Josh, and it should have, and that they have every right to hold the permit because of the amendment to the original nursery decision that allowed the children to also hold a permit. And that those two individuals, in this case now Maggie and Josh, could use a corporation to run their business. So they could have used another entity. They could have used, this is a very closed corporation. It only has Maggie and Josh in it now. It once had their mother. It's never been anything beyond the family members. They didn't necessarily have to use a corporate form of business, but they chose to do that because that's the way their father ran the business. So this has always been the history of Thayer Nursery, and the very essence of this bylaw that was passed in 2014 and amended in 2016 was to allow existing landscaping and nursery businesses to continue to operate under a lot of very tight conditions that would protect the neighborhood. That's exactly the kind of permit that was issued in 2016. It's been, difficult for Thayer Nursery to operate under all those conditions, but they have, and they've complied with them. And at great expense, they've put in all kinds of measures that were required by that original permit. They're continuing to operate. They're continuing to be closely monitored by the building department. And Mr. Prondak visited them shortly before your hearing, and at the time this request for enforcement was filed, to see that they were still operating the way they had always been, which is that Josh and Maggie are on site every day. Maggie is always on site. She does the office operations and the operations of the nursery at the site, and Josh goes off the site every day and works in the landscaping business. That has never changed. That's exactly consistent with what the landscaping permit requires. And it's also consistent with the original nursery permit. So those are my comments. I think this question has been answered in the appeals court decision and in the most recent land court decision. This is the same discussion that we have had before the appeals court and the land court. The evidence of, corporate documents being filed by Maggie and Josh is similar evidence to other corporate documents that were presented to the court and the appeals court and the land court. So I don't see any difference in the issue that's being presented to you today. I think it's already been decided. Thank you.
Okay, thank you, Mrs. McKettrick. Let me just ask whether there's any other citizen or other person present at this hearing who wants to be heard. Crystal, do we have any hands?
No, John, there's not.
Okay, so I think with all of that, it's appropriate to end the evidence portion of this particular hearing, and I believe the board is prepared to discuss this application in open session and vote on it here and now. Is that fair, Mr. Mullen? And Mr. Neighbor?
Yes.
Okay. So Mr. Mullen, do you want to be heard first as a quasi-senior member of the board?
So I think this is a bit of confusing set of facts that Mr. Dunn has been saddled with, and I think has done a nice job of presenting them to us as logically as he can. And I think that it could be, and it probably is, that it would be nice from my perspective to have a more clear line of organizational chart, if you will, or some type of operations chart for the nursery. But I think at the end of the day, I don't see anything in the bylaw that requires that the operator hold a special permit, nor do I see any evidence that the holders of the special permit transferred their duties that are in the special permit to any third party. I too read the land court and the appeals court decisions, and it seems to me that the court considered and addressed those issues. And I think there is a reasonable case to be made that it's proper for Margaret Oldfield and Joshua Oldfield to hold the permit for any number of reasons, including the reasons that Mrs. McKettrick set forth in the presentation. So on the basis of those reasons, I would hold in favor of the building commission here and uphold the issuance of the permit.
Okay, thank you, Mr. Mullen. Mr. Davis, please.
I have pages and pages of notes I've made and comments on the court decisions, and some of them I've gone over. But I think Mr. Mullen was able to state to make a statement that's much more concise than what I was saying, and while getting to the the heart of the matter. And part of the heart of the matter was the fact that I guess this has basically been going on for over 50 years too, without the building inspector, the planning board, because it's always been in the name of the individuals in the family. And I guess it's always been Thayer Nursery Corporation, at least participating in operations of the business. And I'm not aware that there's been any objection to that, although they weren't holders of the permit. And as Mr. Mullins said, I didn't see anything that required you to be a holder of the permit in order to be operating the business. And in the case of a corporation, I know that they're separate entities, but a corporation can only act through individuals that are directors and stuff and officers. And in this case, they are dual roles that the Oldfield siblings have. And I think that's an additional reason why it's proper for them as holders of the special permit to be able to be considered to use that corporation, of which they're the sole owners and the sole directors and officers in the operations of the business. So I would agree with Mr. Mullen and side with the building inspector.
Okay, thank you, Mr. Daber. From my perspective, I agree with Mr. Mullen's introductory comments. Mr. Dunn has made the best case he can under the circumstance. He's always been a well-prepared and diligent attorney representing Mr. Johanning and Mr. Rowe, and he deserves commendation for his efforts on their behalf. And I think Mr. Dunn has made the best presentation he could under the circumstances. I look at the evidence differently. I think that Mrs. McKettrick's argument that this matter has already been decided in the land court, and which decision was affirmed by the appeals court when the Justice Rubin in the land court indicated rather plainly that Josh and Maggie Oldfield are not prohibited from using Thayer Nursery Corporation to facilitate and assist them in operating the nursery aspect of the business. She cites well-recognized Massachusetts law that one or more corporations may be formed to carry out the objectives and purposes of the persons, the individuals controlling them, and there's no impropriety in that at all. And maybe it would have been easier and cleaner and clearer if their nursery had formed another LLC just to operate their landscaping business. But I don't see any legal obligation on them to do that. The question of what was actually happening in the field was raised by the applicants. Mr. Prondak conducted an investigation. He actually went to Thayer Nursery to interview Maggie Oldfield. He did whatever any prudent building inspector would do under the circumstances, and he knows of this, as Mr. Dunn indicates. This has been ongoing litigation for years and years and years, and probably more years in the future. But he made the conclusion that both Maggie and Josh Oldfield were operating the landscaping business together. I see no evidence to support a finding to the contrary and to reverse Mr. Prondak's findings of fact. I think Mrs. McGettrick's arguments that these issues have been decided and res judicata is applicable here. I think it's a very, very strong argument. I don't pretend to be an expert on res judicata, but it seems to me that at some point in time, these issues have to be decided. And I think that Judge Rubin did her very best to articulate the issues and make findings of fact that are fair and make conclusions of law that are fair, all of which findings and rulings in my mind indicate that the evidence is clear that Maggie Oldfield and Josh Oldfield are the holders of the special permit, and they're operating the landscaping aspect of the business as individuals, but through some of the assets of Thayer Nursery Corporation. So I certainly intend to vote to uphold the finding of the building commissioner and to deny the in the building commission is denying the request for enforcement and in denying an order to compel Thayer Nursery to cease and desist operating a commercial landscape business on the site. So I think that it's rather clear from my perspective here that this matter does not end here. I wish it could, but it's not going to. So I think we render a decision based upon the evidence as we see it, and wish everyone well to in the land court or the appeals court or the Supreme Judicial Court. And this could easily go on for 3 or 4 or 5 years of such litigation, and it's unfortunate, but everyone has the right to pursue their legal interests and their view of the evidence. And all I can say is this hearing has been conducted in a very it's a technical hearing that's been conducted in as basic manner and in good spirits with all, and good faith with all people. And we'll do our part and wish everyone well in the future proceedings on this particular application. So all of those board members voting in favor of affirming Mr. Prondak's actions and denying Mr. Johanning and Mr. Rowe's request for enforcement, and denying the order compelling Thayer Nursery cease and desist operating a commercial landscaping business, please say aye.
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 So we have a unanimous vote. And I will take a run at preparing a draft decision here for the board post haste, so that everyone can continue pursuing their legal rights. And if does anybody have anything further to present before the board? I don't think there's any other action that needs to be taken. And if that's the case, I will do my best to crank this out with some degree of dispatch. I want to thank everybody for their participation in this matter. I want to thank Mr. Prondak in particular for his diligence on this application, as well as Kevin Freitag, our lawyer and counsel, for attending these matters and reviewing the evidence, and for his assistance. And with all of that, this hearing of the Board of Appeals will be adjourned, and I wish everyone a good evening and look forward to following this case as it proceeds through the judicial system. So have a good night, everyone.
Thank you, everyone.
Thank you.
Good night.
Good night.
Good night now.